Byron Henry joins me now, who's an attorney and partner in the appellate law section of Scheef and Stone, which is a business litigation and civil appeals firm. Mr. Henry, thanks for taking the time.
Glad to be with you.
So yesterday we talked a lot on the show about the Washington Supreme Court's decision in the case of Baron L. Stutzman, who is the owner of a floral shop in Richland, Washington, who 3 or 4 years ago turned down a gay couple that she had sold flowers to many times before, but she said she did not want to provide flowers for their wedding. I thought she was within her rights because she said participating in a gay wedding, even by doing the floral arrangements, would violate her closely held beliefs. The Washington Supreme Court says she's guilty of discrimination. Who's right in that case?
Well, there's a couple things to consider there. First and foremost, of course, you know, the Supreme Court and the United States Constitution has a free exercise clause which guarantees the free exercise of religion by citizens. Washington, unlike 30 other states in the United States, does not have what's called a Religious Freedom Restoration Act, which basically provides extra statutory protection and basically flips the burden from the person who's trying to practice their religion to the other side to prove that something doesn't burden their religion. So what we have here is a case where they're saying that it's more akin to refusing service to an African American or someone because they're old or someone because of their gender than it is about exercising religion. And I think you in your lead-in said it best when you said there's a difference between you going in to a hardware store and choosing people not to serve based on prohibited classifications such as age or race or whatnot, to sell them a hammer or whatnot, or to sell them flowers, and to basically be hired to come into their home and participate in the event that they find against their religious beliefs. And I think this is a closer call, such as the baking of a cake or the photographer, but I believe that the Free Exercise Clause, and certainly a state that had a Religious Freedom Restoration Act, the florist would have prevailed. But this is an analogical stampede towards if you want to exercise your faith in this country and it does not comport with the secular humanist worldview of these anti-tolerant, anti-religion statutes and whatnot, you are going to be, in some states like Colorado and Washington, you can be fined. And if the United States Supreme Court doesn't take this up under the Constitution, there's really not a whole lot they could do. I mean, same-sex couples could target Christian-owned businesses, whether it's florists, photographers, across the board. And if they do not want to participate, they could basically put them out of business.
I mean, for example, this hasn't come up yet, but Mr. Henry, what happens when the first transgender man who calls himself a woman walks into a bridal dress shop and says, I want to buy a bridal dress? And the shop says, no, we cater to women, and you're not a woman. Are they going to be within their rights to refuse?
Well, certainly based on this decision in Washington, they would not be within their rights to refuse unless the court somehow, twisted it where sexual orientation is not included in gender identity. But assuming that gender identity is a classification either based on gender or sexual orientation, then the answer would be they would not be within their rights to refuse to sell or to fit someone for a wedding dress just because they were transgender male or female. That is correct.
I'm talking to Byron Henry, who's an attorney. Mr. Henry, I'm not an attorney, but tell me this. I don't even know if the proponents for Baron L. Stutzman advanced this argument, but I saw her discrimination, and I don't mind discrimination in the sense that I discriminate. I say I want to go to that restaurant instead of this restaurant. I make choices. All of us make choices all day long. She was not discriminating against a person or persons. She was discriminating against an event, the wedding.
And once again, that's the fine distinction of how I use the example a lot about a person that wants to rent a room or rent out a room in their home. That person can discriminate based on a lot of factors, but under these new laws, you couldn't discriminate because people weren't married and they wanted to come live in your rent a room, and you had a rule that said only married couples. Well, you'd have to allow same-sex couples and whatnot. So discrimination versus participation. I do believe the case law is pretty clear that as far as just serving people, meaning serving people in a restaurant or giving someone a hotel room, public accommodations, it's pretty clear you cannot discriminate based on some factors, race, age, gender. There's a certain line. But this is different than that, and I think the point is is that if you are required to do more than simply sell your product that's open to the public, if you are required to participate in or meet with or endorse a certain conduct or a certain event, I think that is where the line should be drawn. And in most states that have Religious Freedom Restoration Act, it would be easy to satisfy the burden that while selling my product to homosexuals or to same-sex couples does not unduly burden my religion, actually participating in a wedding by being the baker or providing the flowers or being the photographer would unduly burden my religion. Washington doesn't have that, and that's why it is very important that religious liberty advocates continually advocate, one, for the enforcement of the free exercise clause of the First Amendment, but two, for the passage of strong religious rights legislation at the state level.
And as I understand, the state Supreme Court in this case also rejected the idea that making floral arrangements is in any way, shape, or form expression under the First Amendment. That one doesn't make sense to me because every single wedding is done slightly differently to cater to the interests of those getting married. How can that not be a form of expression, but setting a flag on fire is a form of expression?
Yeah, I agree with that. There's two things I find problematic besides just the overall idea that someone can be forced to participate in an event they find offends their religious beliefs. But the one thing is what you just said about whether or not it's expression. I think they're wrong on that. I think whether you design T-shirts or clothes or bake cakes or decorate cakes or create flower arrangements, that's all free expression, and it is all covered by the First Amendment, even if it's a commercial enterprise, by the way. Just because she sells them does not take away the First Amendment expression. The other thing that bothered me about the decision was normally when a party says participating in this event would offend my religious beliefs, the courts take that at face value because the Supreme Court has said that courts are not in a position to decide whether or not something does or does not actually offend someone's religion, because we don't want the courts being a religious court saying, well, no, that's not one of the tenets of your faith, or that is one of the tenets of your faith. Here the Washington Supreme Court said, you know what, we really don't believe that simply doing the flower arrangements for a same-sex marriage would offend your religious beliefs. Not only is it not free expression, and I think that runs counter directly to Supreme Court precedent that says courts should not parse whether or not an act actually offends someone's religious beliefs, because only they know what their own religious beliefs are.
Absolutely. Mr. Henry, thank you very much. You've got the Lars Larson Show.